Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Thank you, Michael, for the introduction. Don, thank you for coming to the show.
Thanks for having me.
Okay,
Appreciate
so
it.
people that have not seen our show before, just give them a little background about you and your company.
Well, my name's Don Ross. I'm an attorney here in Naples. Been here since 1985. I have a degree in taxation as well. I am a shareholder in Ross, Lanier & Dyfick, a law firm. I own Ross Title and Escrow, a title company, and I'm a shareholder in Downing Fry. On top of that, I've been in-house counsel for Downing Fry for about 25 years. Our office is located in the corner of 6th Avenue North and 41, right across the street from Pastrami Dan's. Nice, easy place to find. I have approximately 8 people who work for me, been with me from anywhere from 2 years to 30 years, and half of them are related, so it's a good, tight group.
It's a great group. I know we do all our closings, and our clients come out of there and they say, boy, what a nice people and how efficient they are.
Well, thank you. Appreciate it.
Don, last month we talked about our real estate contracts, some of the common mistakes people make and when purchasing or selling a house. This show we'd like to talk about people that are going in new communities, because those contracts are completely different than the ones we use for a regular real estate transaction here in Florida or Collier County. One of the key things that I always say before we get into the contracts is that, you know, a realtor, they should have representation going into a new community, and bring a realtor with you, just because it doesn't cost them anything.
Right.
Okay, and you have a second opinion on, because when you go in there, you're only going to get one side of the story. And typically, I think it's a smart move for them to bring somebody in there. Doesn't cost them anything. If they go in there without a realtor, they fill out a form, and if they don't put a realtor's name down or tell them that they're represented by a realtor, they might be giving away their rights to be represented by a real estate agent.
You're absolutely right. And I mean, a lot of people will go on the weekends and just go wandering around. They'll hear of an open house. They'll want to go see it, and they don't want to bother you. They don't want to be a pest. But what they don't realize is that the typical developer tries to keep everything in-house. I mean, I cannot tell you how many times I've had people call me and tell me that they've been told by somebody at the developer's office, sales office, oh, you don't need a lawyer.
Right.
You know, we don't need lawyers here in Florida. And I'm sure they do the same thing with realtors.
That's right.
They have a self-interest in keeping everything contained inside their own little community. And they all work for the same person, the developer.
Right.
So they're not working for the buyer. They're not going to sit there with the prospective buyer and go through, and here's a typical contract.
That's right.
Just for viewers.
That's right.
This is what I'm working on. I mean, I tabbed it before you even told me what this show was about. And so they're not going to sit with the buyer and go through this and explain it. I bet you half the salespeople don't understand a lot of this. I mean, because it's very technical.
Yeah, it's written by attorneys.
But to reinforce your point, I mean, it costs zero. And I know it's human nature. You don't want to bother Jim on a Sunday. He's probably with family. But if you just put Jim's name down, or whoever your agent is, that protects you. That has someone on your side. And I know you specialize in these new developments. I've learned things from you, frankly, about these contracts, things I now look for that I didn't look for before, that are very helpful to me. So anything you can do to have somebody who works just for you, a realtor, an attorney, you should do. When you have something this thick, written by lawyers.
That's right.
You need somebody.
Right.
I mean, there's no question. I mean, the NABOR form that we use for resales is 10 pages. This, who knows?
They're 50, 60, 70
yeah,
pages.
it's a multiple set of documents.
So when they do a contract, we sit down and we do a contract. They give them a big stack of papers to
Sure.
look through, and typically they don't give you the contract prior to signing it. That's
No.
what we found out. So we can ask, but sometimes they'll do it, sometimes they won't. So how many days do they have to review the documents once they get the documents? Because that can get them out of the contract
They have
too.
15 days. It's statutory. They have 15 days where they can cancel for any reason whatsoever. And again, using this stack, this is a gentleman, and I'm sure you have the same
That's right.
situation. I have people come back and come back and come back. I'm representing him on a sale, but this one, for a variety of reasons, it was advantageous to him just to use the developer's title company, but I'm still involved. I explain the thing to my client because he is my client. I do other transactions with him,
Right.
and I make sure he's protected. And I point out to him not only the 15 days that you referred to,
Right.
but there was an inspection provision that you pointed out in one of our seminars last year, where he can bring somebody in at right before closing and have it inspected, and they're not necessarily bound by it, but at least he'll have the knowledge of what's considered defective and negotiate with the developer. So it's very helpful to have a realtor, have a lawyer, have the team that stands behind you and I at his fingertips.
Yeah, that's key. I mean, we can talk about inspections, but some contracts you're not even allowed to do an inspection prior to the closing, which again is something a lot of people don't do inspections, or the buyers don't do inspections when they're buying new construction. But I think it's almost as important as buying a resale property.
To me, I realize people don't like to waste money. I understand that part of it. But when you have a transaction like this one, which is a $600,000 purchase, not to pay somebody to go out and do an inspection, to me, seems not prudent.
Right.
And when I talk to my clients about this, it's usually best if you use yourself as an example. I mean, I have 4 children.
Right.
When they were younger, I had life insurance.
Right.
Did I want to? No. Did I think I was going to pass away right away? No. But it was prudent. I had a responsibility. So if the $600,000 in this case is a significant amount of money to the buyer, I tell them, risk reward. You should invest a little bit more to make sure that $600,000 is well spent.
Right. Yeah, and on a $600,000 house like that, it's probably $500-600. So
Yeah, so
not-
why not? I mean,
Right.
you're just going to write a check for $600,000 and not make sure you're getting what you were promised? I mean, it's so much easier to find out about things beforehand than after you move into the house. It's easy to resolve.
In some other points is, let's say there's a dispute. How does that happen? Because they usually have your own money, the developer. They don't put it in an escrow account like yours. They want that 10
They want
or
the money.
20%.
Well, there's usually a block in the contract where the first 10%, if it's checked off, can be used in the development, and then the second 10% is held in escrow. And if you have a dispute over the money, typically they have arbitration, which over the last 30 years I've done maybe half a dozen arbitration cases, and usually they're a pain in the neck. The selling point to the buyer is it's faster and you may not need an attorney.
Right.
There's no opinion issued that gives findings of fact that they apply the law to that you can appeal from. And as an attorney, I have always been dissatisfied with every arbitration case I've gone into. They can, unless you can show fraud or something that was newly discovered that was not considered, you can't appeal from it. So if the person trying the matter, whether it's arbitration or in court, makes an error, you're stuck with it.
Mm-hmm.
And I'd get rulings saying so-and-so gets X dollars, and that's all it says.
Right.
You know, with a court, you submit briefs, there are cases, they're obligated by law to follow, you know, if it's in the 2nd District,
Right.
which is our district, they're obligated to follow those cases. If it's a Florida Supreme Court case, they're obligated to follow that case. And if they don't, you have recourse, you can appeal. So you're trading off the expediency of getting something quick and easy for having it done right.
Right.
And if you're going to do it right. That's always been my feeling about it.
Well, Don, we're going to take a little short break, and we're going to come back, and we're going to talk about, do they have an option of using an attorney or using you as your title company? Okay. We'll be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, let's, when you go through the contract, when we're sitting down with the developer, with their representative, there's usually an area in the contract that they can choose who they would like to have as their closing agent. Could you just talk about that a little bit?
I am looking at it, Jim.
Okay, that's good. It's highlighted.
I'm sorry.
It's
highlighted one of the things
too.
I look for. Yeah, I know it sounds self-serving, and to you know, a certain extent it is, but election form addendum. It's an addendum to the contract. The developer is required by federal law to disclose that they have affiliated relationship with the title company. They have some financial investment in it or relationship with that title company, which in English means they work for the title company.
Right.
It's the title company working for the developer. So in this particular form, they pre-checked it. It's been pre-typed.
Oh,
and they did a little X where the buyer elected to use, and I won't name the title company.
Right.
And they try to, in some cases, they leave it that way. In other cases, they'll tell the buyer somewhere in here that, you know, within 30 days of signing this contract, you can pick who you want.
That's true.
And I look for that. And in other cases, they'll say, if there's a federally insured loan, then you can pick who you want. Otherwise, you can't. In other cases, they'll just shift the costs to both the dock stamps and the title insurance to the buyer, and just leave it at that. But they try to keep you with using their company. They make money off the title insurance. They already know what the title says. They had a, when they bought the land to develop the property on, they got title insurance. So my concern always is, and I use different underwriters. I have multiple underwriters. They they're useful for different reasons. They all have different philosophies. Some are aggressive, some are less aggressive. They are insurance companies, so they're not necessarily creating a document that is entirely going by the law. They're going by risk. Now, they know what the law is. Don't get me wrong. They know the law, but they might require something above and beyond the law so that they don't have to argue about it later on down the road. And then I'll know another underwriter will say, well, the law is this, and we don't quite want all those extra things that the other underwriter is asking for. We're happy if you have this lesser amount. So I'll look at this and say, oh, okay, they've already checked this person. You have these rights to change. And frankly, you should change. From firsthand knowledge, I have seen situations where one underwriter will catch something, the other one won't.
That's right.
And when I talk to clients about it, they're like, well, what's an underwriter? In reality, I'm an insurance agent.
Right.
Believe it or not, that's part of what I am. I'm an insurance agent. An underwriter, in this case, well, with me anyways, I have two, is a big national company worth hundreds of millions of dollars that will financially back these policies that the buyer will get. I'm the one who looks at the documents, I'm the one who is their agent, I'm the one who they come after if there's a mistake made. But the underwriter's, vast financial net worth is behind these policies. So if the buyer can get their own person, they can use the title insurance to, in essence, pay an attorney, i.e. someone like myself, to do all these tabs,
That's
to explain this to them, to explain the importance of the 15-day cancellation period and the inspection clause, and is there a landscaping plan here, and you got to look at the specs, and here are typical issues that come up. And
if you have a truck or whatever,
whether you can, the use
motorcycle.
restrictions, is there an architectural review committee, the things that affect their day-to-day use of the property, and the things that affect their financial obligations relating to the property. So I always try to break it into those two categories, and it's hard when you start with this. This doesn't even have the restrictive covenants.
No, it's very difficult. About a CDD. Explain to our viewers what that is, because I was just doing a seminar the other day, and people didn't know what that was. So.
Community Development District. It's in NABOR. It's in this. The developer, when they get their big tract of land and they're going to have it platted and they're going to put in utilities, they'll raise the money through bonds and sell them, take that money and put it in the infrastructure.
That's right.
They'll use it for the infrastructure, and then it's incorporated into the ad valorem tax bill. It gets paid off over time. So sometimes you can pay it off. Sometimes it's just an ongoing annual responsibility. And with the NABOR contract, anyways, we require that if there is a payoff, that the buyer, it be disclosed to the buyer before the buyer signs, so they know what it is, and then they can negotiate the purchase price based on that in part. If they're assuming a debt of X, it might affect what they're willing to offer. So a CDD is a method of a developer using other people's money to build his infrastructure, and then he passes it along to his customer, and it looks relatively small on the tax bill, and it is relatively small on the tax bill.
It is, right.
But the payoff could be significant.
Right, and then not every community has it, so it's not on every community. It's mostly usually on newer communities putting the infrastructure in, and that bond is usually over 25 years, paid over 25 years, and you have no control over that bond. It's a committee that controls that bond.
You know more than I do.
Yeah, there is. So they can change it at any time too. They can, sometimes communities need updating, so they change the bond, so your payment might go up or the balance might go up for a little bit longer.
Well, it's certainly something you want to check on.
Right.
And again, the buyer needs to know how much it is to pay it off.
Right.
So that they don't come knocking on your door after the closing. So we check that through the tax bill, honestly, and you can see it, and then you can order the payoff.
Now, we're going to take a little short break here again, and then we're going to come back and talk the difference between homeowners association and condo associations.
All right,
okay?
great, sure.
We'll be right back. Thank you.
Thinking of buying a home located in a golf course community in the Naples, Marco, Bonita, or Estero, Florida? Here is what Mark Lai, former PGA winner, says about Realtor Michael York of the York Real Estate Group of Downing Fry Realty.
Hi, I'm Mark Lai. If you have any real estate needs in Naples, Florida, the one company to contact is the York Real Estate Group. Also, if you want a golf course property to invest in, Michael York of the York Real Estate Group is the guy to contact. Michael knows every golf course in Naples. I will tell you this, he's been in the golf business for a long time. He's played all the great golf courses down here, and he is an outstanding realtor. I've known him for quite some time, and he's he's got a lot of integrity, and he very much knows his stuff on all the different clubs here in Naples. So the York Real Estate Group is a great place to start. So if you have any time or anybody that wants to visit down here in Naples and look at the options out there, please contact the York Real Estate Group.
Welcome back. Don, let's talk about the differences between a homeowners association and a condo association.
Well, from my perspective, they're covered by two different statutes. They're two different legal entities with two different sets of legal obligations. Homeowners Association, I'll use Pelican Bay as an example. Everybody down here knows Pelican Bay. You have the Pelican Bay Foundation, and it's the umbrella
Of
for the entire
right.
community. And it's in charge of roads and things like that. So you pay a certain fee to the foundation annually, and it's used for those purposes. A condo association could be within a homeowners association,
Right.
like Pelican Bay. You could have the Remington, some Carlisle, some condominium, and that is covered by Chapter 718 rather than 719, which is homeowners associations. The condo law has been around forever. I think it started in New York, and I know when I was going through law school, a lot of it was New York and
Right.
Colorado, and then they were just starting it here in Florida. They have different requirements contractually. They give, you're required to give the buyer, if requested in writing, the declaration, which is what gives birth to the condominium.
Right.
It creates it. It has use restrictions in it, so I go zip right into the use restrictions, what kind of car you can use,
Right.
pets, lease restrictions, guests, how do you define guests, family, non-family, they treat them differently. So anything that regulates my client's ability to use it, the things they'll notice on
Right.
their day-to-day use of the property. So you have the declaration, the bylaws we gloss over, we tend to gloss over because it's, how do you elect people, how do you conduct meetings, things of that sort. The articles of incorporation, that's what is filed with the state to form the association, the condominium association, so we gloss over that too.
Right.
Then you get into the things that people care about, the rules and regulations.
Right.
No
parties.
No wild parties. You can't be a nuisance. You have to pick up after your pets. They'll
Right.
get into exotic animals. And again, they'll talk about guests, and they'll treat family, in many cases, it seems to be a trend, they'll treat family guests different than non-family guests. Now, my personal theory, and I have absolutely nothing to back it up with, but
Right.
I think there's a presumption that if you say so-and-so's a guest and they're not related to you, you might be not telling the truth. A double
right.
negative there, but
Right.
you might be lying, and I'm just trying to avoid that word. But so that they assume you're not going to charge your family, and they assume everybody else is getting charged. So the newer documents will distinguish between family and non-family guests. So you get the rules and regulations, you get the frequently asked questions. What's the quarterly maintenance? Any special assessment? Is there a land lease? Might have pets, might have a few other odds and ends, things
Right.
that people actually care about. And then the year-end financial statement.
Not the budget, the year end.
Yeah, now statutorily you're required to give the year-end financial.
That's right.
And that's assets, liabilities. And I specifically look for reserves. I'm always asked, are these enough, Don? And in many cases, like I say, it looks like it's enough. A condo association is like a real person. We're trying to assess its financial health here.
Right.
They have X dollars in the bank that they've arbitrarily divided up in between the redoing the roof, painting the building, repaving, all the big ticket items. But in real life, when something needs to be replaced, it's not always a match. I mean, the amount you have for your roof in reserve might cost a little bit more in real life, so they borrow from one of the other funds, and then you have your annual meeting, and they readjust things. They get new bids, what it now costs to do a roof, what it now costs to paint the building or repave the parking lot, and update how much people would pay towards the reserves.
We've had a recent problem where one of our deals was the bank did not approve the association because they just redid their roofs, so they felt the reserves weren't enough, but they build up the reserves to replace the roofs. Well, they replaced them, used the reserves, so then they would build it up again, and the bank wouldn't look at it that way.
Well, and they want to see what percentage of the budget, which is not statutorily required, be given to the buyer. But
Right.
if you want to do a good job for your client, you give it to them anyway, so
Right.
they can see where the money is spent. And they'll look at what percentage of that budget goes into reserves. The irony is, for the very expensive condos, you're dealing with wealthy people who may not want large reserves.
That's
because
Why give them the money?
why give them the money?
Right.
We're not getting any interest on it. I could be using it this
Right.
way or that way. I'll write a check when the bill comes in. They're capable of writing a check when the bill comes in. So it's almost counterintuitive in that situation that the very wealthy developments are held to the same rule as the $50,000 condos or the $100,000 condos. Those folks get the vote at every meeting on whether or not they want to have reserves.
Right.
They can say no, and some do.
Do.
Some do. So those are the things I focus on: the money part of it, and within the year-end financial, the amount of the reserves, and also the accounts receivable. The accounts receivable will tell you, and has told me in the past when we had the recession,
That's right.
that this condo is sick. Their accounts receivable is high. The unit owners aren't paying their maintenance. There's a lot of money owed to the association. So when you see a big receivables number on the
It's a red flag.
it's like, what the heck is this? Now I have clients on these expensive condos who will want to look at like 5 years of financial statements.
Right.
So they can see whether the roof was done in your example,
Right.
and why it is at this particular level. They see the spending history spread out over time rather than just that snapshot of one year. And that's how they evaluate the condo, at least financially. So the condo is 718, the homeowners association is 719. The disclosure requirements for the homeowners association is a one-page document.
Right.
You are not required to give a thick stack of homeowners association documents to the buyer. It's governed by Chapter 720, and it gives a summary of what the maintenance, whether there are any special assessments, are there any land leases in place, and then at the bottom, paragraphs 8 and 9, it says that you can get a complete set of the documents if you want them, either from the public records or from the management company. Most people don't get it. I get some who do. Good realtors, if you have an area that you specialize in, you'll have you'll read them. You got to be careful you're not giving legal advice, but you want to know the use restrictions. Do they allow pets? Do they allow certain types of vehicles? What's the deal on guests and that sort of thing, so that you're intelligent when you're talking to your buyers.
Right.
But you do have to defer the other stuff to an attorney.
Okay. Well, Don, I think this was very informative, and I'm glad
so.
you came on the show today.
Thank you.
And,
Appreciate it.
And I look forward to next month you coming on, and we'll
thank you,
talk
Jim.
another hot topic, okay?
All right. Thank you, Jim.
Thank you.